case we have on the docket is the Owen Peterson versus Flair Fittings et al. And we have multiple appellees on the case. There's a total of 20 minutes. How would you all like to divide your time?
This is Doug Stein for Disney. We plan on, myself for Disney, taking 12 minutes, Mr. Samus 5 minutes, and Ms. Rothfeld the remaining time.
Okay, I'll have you all make sure you keep track of your time and know when to switch in, and I'll let you know when your rebuttal. So you want 5 minutes for rebuttal, or how does it?
So no, we don't get a rebuttal.
No rebuttal?
Right.
Oh, that's, okay, yes.
I'll take 5 minutes.
Okay, you'll take 5 minutes, yeah. All right, whenever you're ready.
Good morning, Your Honors. May it please the Court. My name is Dineen Wasylik. I'm here appearing on behalf of Appellant Owen Peterson, who is here in the courtroom today. And this is an appeal of grants of summary judgment in a personal injury case. There are 3 very important issues arising in this case. One substantive law, one procedural law, and one constitutional law. On the substantive side of it, the issue is whether it was permissible to grant summary judgment on a release of liability that was signed after the injury that's at issue in this case, and being applied to injury that happened prior to signing of this agreement. It is our position that that waiver, which was entitled in big bold letters, sports waiver and permission form, and that's in the record at 976 if you need to look at it, very clearly, or is not very clear. To the extent that it is clear, it seems to be saying that it's waiving everything from the moment you sign it on, and should not have been applied to forbid the suit of something that happened, injury that happened prior to signing that waiver. Florida policy is very clear that there is a material difference between waiving your rights to something that's going to happen in the future and waiving your rights to something that has happened in the past. The considerations that you make when you're deciding to enter into that kind of waiver are different. And because waiver of rights is something that Florida is loath to have happen, you have to be very clear what you're asking someone to do when you ask them to sign a waiver. The waiver...
Ask this.
Sure.
Although it appears the waiver was prepared as, pre-event, and the facts of this case occurred, signing the release occurred after the event. So my question to you is, view it that way, that this document was signed after the alleged injury and the alleged negligence. Could you set forth what you believe the deficiencies are, recognizing that it is a post-event release?
Yeah, well, I think in this case, that this post-event release doesn't expressly say that it's waiving anything that happened prior to signing. I recognize that there is some language in there that says before, during, and after your participation, but if you look at the case law, every single case that talks about a release in that context, the document was signed prior to the injury. So, when you're releasing rights, before, during, and after, can't mean from the beginning of time to the end of time, or shouldn't mean from the beginning of time to the end of time. If he went to Disney, 5 years prior, by signing this now, he shouldn't be releasing something that happened 5 years ago. Or if he goes to Disney 5 years later, by signing, perhaps that's a bigger issue. But it has to be tied to participation in the sport event. And in this case, this release talked about sporting events, sporting event, sporting event. You show that you are able to, that you're saying that you're fit to participate in the sporting event. You understand that you could, break your leg in this sporting event. And so in that context and that timing context, reading this document, you wouldn't know that you're being asked to release hitting your head 2 days prior when you were not yet participating in the sport. This release includes, as part of the release parties, the hospital that treated Mr. Peterson 2 days prior and released him and said he was okay to participate. So there's nothing in here that's indicating that the thing that happened 2 days ago is being covered by this. It's saying it's conditioned upon your participation on forward. His participation, anything he did prior to the date he signed it, there was no condition for that participation. He was not told, in order to walk in the door 2 days before you're going to play paintball, you have to sign this release and it's going to release everything. There's plenty of instances and plenty of cases where before you walk in the door, you sign the release, and then everything during your, the time you're in the door is covered by the release. But that's not what happened in this case. That's not what's indicated. I think the public policy of the state of Florida is strong enough against these types of releases that when you read this in context, it does not clearly state that you are releasing past action. And there's no way for him to know that he's releasing past action.
Injury occurred in the vendor area, is that right?
Correct.
Okay. Was there any requirement, facts of the case, for people entering the vendor area to complete a release prior to entering the vendor
There's
area?
nothing in the record to indicate that, sir. So, I mean, if there was, then we'd have a different case. We'd have a very different case, and that's my point. There are some of the case law that we talk about. One of the cases where it was entering a motorsports facility. You had to sign the release before you even walked into, in the door. Then maybe, if you got hit on the head while you were buying a concession, you were still covered by that release. But here, there was no release signed prior to walking in the door.
In fact, the release, though, says any activities surrounding the event, essentially.
Yes, it does say that, but again, it's saying in consideration of your participation today, and it does not indicate that it applies to anything that happened prior to signing this document. So if he had hit his head the day after, I think that would be a different story. And I think the case law says that would be a different story. But the kind...
Or during or after such participation?
Sure, and, then the case law, such as the other Disney case that was cited in the briefs, someone's riding their bike prior to the actual event, but they signed the release before that. And I think that you have to read time into that release. The before, during, and after has to be from the moment I signed this on, and not 2 years ago and not 5 years from now. So I think that is, there's just not clarity, and to hold as a matter of law that this release is applicable to what happened 2 days ago, I think is premature. If there's any doubt as to how this should be interpreted, at that point it becomes a question of fact, and that should be something that should not have been done on summary judgment. So as to the release issue, I don't think that this release is, as a matter of law, binds prior actions prior to the signing of the release. And the other issue that I do want to address is the grant of summary judgment to the other defendants, to Crossfire and Flare Fittings. Procedurally, those summary judgments fly right in the face of sort of the main Supreme Court case on summary judgment, Hull v. Talcott, which says you have to show that there's no possible facts, and just saying they don't have anything isn't affirmatively making the showing that's required for summary judgment.
Let me ask you about what was presented to the trial judge.
Sure.
So there's one deposition in the record, is that correct?
That's correct. That's the only deposition in the record. Correct.
And there's no affidavits.
Correct.
Other than
Plaintiffs
Mr.
fired, no affidavits.
Wright or whoever.
Right, and we're not here on that one.
Okay. And any interrogatories, requests for admissions that don't relate to injuries, but that relate to whether there was negligence or what relate to duty?
Not that I have seen in the record. There may have been something that's not in the record that I'm not aware of. I was not trial counsel, but not in the record. There's nothing that the trial court could have based that on, based a holding on that. And frankly, even if there was, the rule on civil procedure on summary judgment requires that you identify which of those things in the record you are relying upon to show that there is no duty owed or those kinds of things, and that was not done here.
So leaving out the release issue, the only facts going to either duty or going to liability that were before the court, the only thing of record was the deposition of your client, nothing
Correct.
else.
That was the only thing that was in there. But, as far as, was my client required to come in and rebut whatever they said, the answer is no, because they did not meet their initial burden on summary judgment. They didn't have affidavits. They didn't direct any of Mr. Peterson's prior testimony or any of their own testimony to what the duty was. They just said, he hasn't shown it. And that is not enough to get summary judgment. You have to make an affirmative showing as to why you do not owe that duty. And I cited plenty of case law as to why there likely is a duty. Again, I mean, I'm not asking you to find that there is a duty because it's not appropriate at this time, but all I'm saying is that on summary judgment, the defendants did not make a showing, did not make the affirmative showing that there's no way he could prove a duty. They just said, he hasn't shown us anything, show us what you got. And that is not the way summary judgment works in the state of Florida. So as far as the summary judgment is concerned, there's just no factual basis to hold that these defendants did not owe a duty. In fact, the facts that are in the record show that there could be a duty. Mr. Peterson testified that that when they went to the tent and told them that they had gotten hit, that the balloon was taken down. There's case law that says that, taking that stuff down shows that you have control over that. The law on invitees that I've laid out in the brief, and I would rely heavily on the brief, shows that if you have any control over that, then you potentially owe that duty. So I think that the only facts that were in the record actually affirmatively show that there could be a duty. Whether or not it would ultimately be proven, I don't know. But certainly on summary judgment at this stage in this procedural posture, we're not there. And summary judgment should not have been granted in this case. I do want to mention briefly also just the due process issue of the fact that the court refused to grant my client an enlargement of time to find counsel after letting his counsel out basically 2 weeks before trial. Getting a lawyer to even call you back in 2 weeks with a new case can be difficult, and the trial court absolutely
Case has been pending for 6 years, right?
Right, and so letting his lawyer who had been representing him for 6 years out 2 weeks before trial and expecting a new lawyer to come in and pick up a 6-year-old case and figure it out and try it in 2 weeks is just not reasonable.
What was the length of time between the motion to withdraw filed and the hearing on the summary judgments?
Very short. I believe that was around 2 weeks as well. It was a
2-month period, though, that the attorney represented that he'd been telling the client? There was something about a 2-month period of time.
The client was opposing this withdrawal actively and, put his faith for good or for ill in the fact that, what do you mean you're going to let my attorney out when I've hired this person and they've agreed to represent me?
He had been looking for another attorney.
At the hearing where he asked for the enlargement of time, he said that he'd been diligently searching for another attorney, and the court took that at face value and said, yes, you're doing the right things, but I'm not going to give you more time. And what is particularly difficult to swallow from the perspective of a client, of a person on the street, is I don't understand why I can't get more time to find a new attorney and he can get more time because he's in Europe. Now, I understand it as a lawyer, and I don't begrudge someone asking for, I'm going to be out of town, may I have an extension on this deadline, as a professional courtesy. But when a lawyer's extended professional courtesies and someone who's been left unrepresented is not given more than 2 weeks to find someone to pick up a 6-year-old case, practically speaking, asking someone to pick up a 6-year-old case in 2 weeks is near impossible and is a violation of due process.
Set a status conference between the time that the counsel was allowed to withdraw and when the case was set for trial?
I'm sorry, can you repeat the question?
Did the trial judge set a status conference as far as how the plaintiff was progressing in hiring a new lawyer to represent him in the meantime?
I honestly don't recall, Your Honor. I'd have to check that on the record. But I do know that things went forward pretty quickly after the withdrawal was granted. We don't, unfortunately, have transcripts of what happened after that, so there's just no record to say what was discussed. But I do know that my client did file an additional motion for more time, which was denied, and that's the motion where they set out what efforts they had been making to find additional counsel, and that was denied, and that's what we're...
And so the trial judge had a case that was 6 years old, one deposition had been taken, and counsel for the appellant, had then requested to be withdrawn from the case, correct?
Correct.
Okay, so when does it get to the point where the trial judge can go forward with the trial based upon your viewpoint?
My viewpoint is either don't let the lawyer out and make him try the case that he's been on for 6 years and not let him out 2 weeks before trial, or, and I know that that's tough from the lawyer's perspective, but, or, I mean, at least, 6 weeks, 2 months, something. The fact that 2 weeks to get a new lawyer is just,
The motion of the trial was March 19th. The summary judgment hearings were May 13th. That's about almost 8 weeks.
right. The summary judgment hearings were actually put off because the original case management order said they had to be earlier than that, and then the defense counsel asked for more time. So, even with that 2 months, he actually moved for another motion for longer time because he was continuing to look for an attorney to represent him. And, had he had an attorney, perhaps things would have turned out differently, but, even on this record, the substance of the release is not clear, is not clear enough to say that's a pre-release, pre-signing release. The summary judgments that were granted just said, he has to show me something, and that's not what Hull v. Talcott says summary judgment is in this state. And then there's also the due process issue. Unless the court has any other questions, I'll just reserve the remaining of my time for rebuttal. Thank you.
Thank you.
May it please the court, Doug Stein for the Disney Appellee, and again, I will be addressing the issue of the release and the continuance. Since we just ended the argument of the continuance, let me address that first. Your Honor, it was 6 weeks between the time that the appellant's lawyer, excuse me, withdrew, or the order entered allowing him to withdraw was entered, and when the summary judgment hearing occurred and the summary judgment was entered. Number one, there's been some comment about should not have let the lawyer out. Well, there's been no challenge of that order allowing the lawyer to withdraw. Not only was it 6 weeks in that time period, at the hearing on the motion to withdraw, I'm going to call him the plaintiff, I'm used to that, the plaintiff's lawyer stated that he had informed the plaintiff 2 weeks earlier that he was going to withdraw and that the plaintiff needed to start looking for a lawyer. So it was actually 2 months before the summary judgment was entered that the plaintiff knew he needed to have a new lawyer, not to mention the fact that the final judgment wasn't entered and the time for rehearing hadn't expired until a month after the summary judgment hearing, at any time at which a lawyer could have made an appearance and filed memoranda, motion for rehearing, whatever the case may be. So there was a 3-month period of time in which the plaintiff knew that he needed a lawyer to the time that this case was finally resolved by a judgment, and there is nothing in the record whatsoever to indicate what type of effort the plaintiff made to obtain a lawyer. There's no transcript at the status conference hearing that did occur. And this is an abuse of discretion standard. There is nothing in the record to indicate that the trial court did not review all of the factors that were necessary to determine whether the summary judgment hearing should be continued or not. And there is nothing in the record to indicate that the trial court abused its discretion under these particular circumstances in not allowing the continuance. Not to mention the fact that it's virtually harmless error, because on the summary judgment issue, it's a de novo review in front of this court. This court is giving the same review that the trial court gave down below, no matter what a trial lawyer would have argued or not argued. So they're getting the same review here as they would have had below if they had a lawyer. Let me turn now to the release. This release was signed by an adult of, I assume, at least average intelligence, who read it. It's undisputed he read it. It's undisputed he had an opportunity to ask questions, and he asked no questions about it. The release defines the event, and that is a term that's defined in the release, which the plaintiff attended as the 2006, this is the quote, PSP Orlando World Cup.
Let me ask you about that, because I have a concern about the definition of the event that you're asserting here. you know, this is for paintball competition, so I guess you could define the event as the paintball competition itself from the time, you know, whoever says game on till game before it. Could be expanded to include, you know, putting on the equipment, testing the equipment, et cetera. You know, here you're trying to expand it to include walking into, you know, going by exhibits. Okay. And the question I have as far as, you know, should I be concerned whether there's an ambiguity there, particularly since the release, the individual declares that they're physically fit and have the skill level required to participate in the event. And so my question is, you know, why would you have to declare that you're physically fit and skillful to walk through an exhibit area?
Well, Your Honor, here's, first of all, we're not trying to expand anything. The event is defined in the release as being the paintball competition and any other activities that are in conjunction with the paintball competition.
That's what it says, any related activity.
Correct. So
Does that include, for instance, parking, driving up and parking in the parking area to walk into the exhibit area?
I think
That related activity?
I think there may be a gray area where Your Honor, yes, I mean, I think maybe it is, maybe it isn't, but this is not in that gray area, and it has never been argued in this case that the paintball vendor activities that were going on at the same time as the paintball competition were not related to the paintball competition or were not part of the event.
But we have to determine if summary judgment is appropriate. It's only, as far as your release argument, it's only appropriate if this release is unambiguous.
Correct.
As far as the event in question. Now, the release defines, it says event and any related activities.
Correct.
Related activities is kind of a broad term, and in trying to define the broad term, I think it's appropriate to look at the rest of the language in the release, because we have to look at the whole thing, and it has language saying that that you declare that you're physically fit and have the skill level. So I'm trying to see how a declaration of physical fitness and having skill level would be supportive of your position that walking through a vendor exhibit is a related activity.
Well, I think we need to take a look at this. We need to take a step back and why did Disney have them sign this release to begin with? Because like Your Honor pointed out, you certainly didn't have to sign a release to walk through the vendor area. You had to sign a release in consideration for playing paintball. And in return for the right to play paintball, the plaintiff, as everybody else did, gave up their right to assert claims that might have arisen at being at the event. Now again, there is no dispute in this case.
Well, if you're seeking a release for events, for injuries that can occur in the exhibit area, why would you limit that release to people who are playing paintball and not to anyone coming into the exhibit area?
Your Honor, none of this is in the record, okay, but we do have an answer.
No, but you made
You're
a summary
correct.
judgment,
I-
and the record is devoid
Correct.
of any evidence that anyone was asked to sign the release that was just coming as a spectator.
Right, so the question is, why did Disney pick out the people who wanted to play in the competitive sport activity to release other claims that might have occurred, for instance, in the vendor area? And Disney has been at this for quite a while. And people who sign releases for injuries that may occur during the sporting event know that they've waived their claim for the sporting event. So those people, and I'm not saying the plaintiff would have done this or has done this, have a tendency to know that they released their claim and to, instead of saying that I turned my ankle in the sporting event or I injured my rib in the sporting event, I actually injured it when I was looking at the paintball competition. I got hit by a balloon, I fell over a curb, or whatever it is. So it's for that reason, to prevent those type of unscrupulous claims, that Disney says, if you're going to compete in our paintball event, we're going to make sure that we're not liable for your injury that occurs anywhere connected with this event. And once again, there is no dispute in this record that the activities occurring in the vendor area were activities related or part of the event. In fact, in the
Yes, if the vendor area had restrooms, in them, and the individual paintball player who signed one of these got injured or slipped and fall in the restroom. Is that a related activity because it's in the overall exhibit area?
Yes, Your Honor, absolutely yes. I think there would be no question about that. Disney isn't in the business of having people, sign releases when they walk into their parks or anything like that. So they're not interested in having everybody release their potential claims against them. And what counsel says, well, this is releasing claims for 2 years out and 2 years back. No, it's not. It clearly states that it has to be an activity connected with the event. In fact, in the plaintiff's opposition to the defendant's summary judgment motions, which may or may not be in the record, he referred to himself as a spectator. Now, we all know that his allegations in his complaint throughout this case have not been that I was injured when I was watching a paintball competition. He claims he was injured when he got knocked in the head by a balloon. But he refers to himself as a spectator. So even he has acknowledged that his activities during the trade show were activities that were connected and in conjunction with the event. Now, they've tried to make this distinction between pre-injury releases and post-injury releases. And all of the cases that they have cited, which have stated that pre-injury releases are invalid and post-injuries are all the cases they cite in regard to invalid releases all have to do with minors, all have to do with children. And the Supreme Court has finally came out with the case, I'm not going to pronounce it correctly, Salazo or whatever that case name is, which states that parents have no authority to release claims of their children. That's the state's responsibility to protect the children. However, this court has stated in the cases that we have cited that when it comes as to an adult, and especially when we're talking about a post-injury release, that it is the responsibility of the adult to make a decision. Mr. Peterson knew that he got knocked in the head the day before, yet he wanted to play in the paintball competition. So he made a decision for himself as to whether he was going to waive this claim in return for playing paintball. They claim in their brief that there was no consideration. I think I heard that in the argument this morning. Of course there was consideration. He would not have been allowed to play in the paintball competition if he didn't assign that release. That was the consideration. In return...
So you think the language in the release specifically puts him on notice that he was waiving the prior injury?
Absolutely, Judge.
You think the language is clear in the release?
Before, after, or during the event, absolutely. And that's the exact language that was held to be unambiguous by the 4th District in the Banfield case. Again, what else could it mean? Before, after, or during the event? For an injury that is connected with the event, not injuries for all time, before and after.
What about the fact he'd already been told by a Disney representative that Disney was going to pay his medical bills and take care of that injury? Does that have any effect?
I think that they said that they would supply some medical information. I don't see how that affects the release. He signed the release. There's been no allegation that there was some sort of contract created or something like that, which for the amount of his medical bills, anything like that. He has sued them for essentially negligence. And the fact that somebody said that they would pay, for him to get checked out has no effect whatsoever on the release. I see that I'm beyond my 12 minutes, and I don't want my colleagues to get upset at me. So I'm going to sit down and let them talk about their issue.
May it please the Court, my name is Scott Samus. I represent the Appellant Flair. The argument is that there was a need to bring forward some sort of an affidavit to set up the summary judgment for Flair and Crossfire. And our answer to that is not necessary when you have the sum total of the plaintiff's case as your offering. The summary judgment standard is, are there any disputed facts? And what are the inferences of those facts? It's kind of actually, I'm glad that there was a C4 motion before us because it's, as Your Honor observed there, we're accepting the story that Mr. Peterson is telling. We believe you. And that...
But on the plaintiff's deposition, he doesn't have to be the sole witness or witness that knows all the surrounding events. I mean, you know, look at a malpractice case when something goes wrong in surgery, the plaintiff's unconscious, you know, that person's not a witness as to the negligence. I mean, how do we know from the record before us that the plaintiff couldn't prove his case through other witnesses?
Because with what he says and the fact that there is no discovery pending, there's no motion for rehearing, he is essentially, when we go to our motion for summary judgment, and again, there's no transcript here, so we don't know what happened at the motion. There's no protest that I need to do more discovery, I can get affidavits, I need to do discovery of someone else. So the idea that we need to allow this to go further really can't be a basis for reversal here, because that's all been waived. It's like they say in the Ailes case, Zarate and Rose versus Clement. We don't know what happened at that summary judgment hearing. We don't know what was waived. We don't know if there was a request for all those things. There's no argument in the record with respect to the motion for summary judgment where he says, there's more, there's more. And in fact, the record affirmatively shows that there's no more because there was no outstanding discovery. This thing, as Your Honor pointed out, 6.5 years post-accident, we're still litigating this thing, and we're accepting his story. And his story...
The story was that there was a 10-foot balloon that had labeling, I think it was Crossfire, on the balloon, was up in the air, the balloon came down, hit him on the top of the head, and then once the complaint was made about the balloon was removed or was taken down. So it wasn't the allegation, I guess it wasn't a further threat to anybody else. Why isn't that enough?
Because it doesn't... There's a hot dog vendor on the corner of the street who's got, in my office, it has Coke, $1 on the sign next to his cart. If that Coke sign tips over and hits somebody, that's not enough to create a cause of action against the hot dog, against Coke. Maybe it's against the hot dog vendor. Anybody can fly a Crossfire balloon. Every 7-Eleven in this country carries all kinds of products. Here, there's no connection, and my client is even further removed. He doesn't know if he's a parent. He doesn't know if he's doing business.
You know, you're saying that your client was not, you know, involved in that at all. That may well be the case, but normally I'd expect an affidavit saying, you know, I have this booth and I have no control over this balloon. I didn't put it up, I didn't maintain it, I have no control over it. And, you know, that's what I'd expect is an affidavit that says, I'm not, you know, if this balloon did fall and if this balloon did injure the plaintiff, I have no involvement, no responsibility. Something from, I mean, it just seems to me the trial judge had nothing on one side and nothing on the other side, or a little something on the plaintiff's side and nothing on the defendant's
Well,
side.
I would submit, Your Honor, that he had everything from the plaintiff's side, the sum total of the plaintiff's case for that very reason. And in fact, submitting an affidavit that just says it wasn't our fault, I mean, those are exactly, that's why those cases, the malpractice cases that are cited, including Hall, don't apply in this case, because there they were depending on conclusory affidavits, essentially affidavits from experts saying it wasn't this doctor's fault, it wasn't this lawyer's fault.
Someone associated with the plaintiff go and talk to someone at the booth?
Some of his friend went and talked to somebody at the booth, and the balloon came down.
Is in the record what happened in that conversation?
No.
So, I mean, for all
And
we
it's-
know,
It's double hearsay.
well, but for all we know, the plaintiff's friend could testify, you know, at trial, if there had been a trial, the defendant told me they were sorry, it's their mistake, they'll take it down. I mean, we don't know because we don't know from either side what happened.
That's why it's waived. Because in order to preserve that argument, there has to be a transcript where he said, or discovery.
Proof.
Pardon me?
Who has the burden of proof?
We have the burden to show that there is,
By what means? Competent evidence?
by the undisputed facts. And the undisputed facts are in the form of his testimony. If he had a friend who could say that, yeah, this was the Crossfire thing, that needs to be in the record. There needs to be an objection to it. I need to take this person's deposition. I need to do more discovery. So all of these protests, and I understand, had he said that at the summary judgment hearing or submitted an affidavit, Your Honor, we wouldn't be here
But it
because,
seems like you're putting the initial burden on the plaintiff rather than the defendant.
no, the initial burden is on us, and we met it by giving the court his case, the sum total of his case in his own words.
Well, let me
And
ask
it's
you
still not enough.
If you had a car car accident, car collision, and you have a plaintiff who sues the other driver, and no one takes any depositions, and there's no affidavits, can the defendant get a summary judgment there?
No, because there, you don't have the whole story sworn to by the plaintiff.
Well, but that's, where do we have the whole story sworn to by the plaintiff?
We're accepting
Can't the
it.
plaintiff just give part of the story, and the plaintiff's witness, plaintiff's attorney, or whoever can produce other witnesses?
They can, but in order to establish those elements, you have to object. When you go to summary judgment, say, look, we're accepting your story. It's like a C4 motion. We're accepting it. And as a matter of law, you can't prevail.
Well,
It's like-
let me change my hypothetical a little bit. The plaintiff and the defendant have a car accident. Plaintiff gets injured, has no memory of the event, but there's other people who were present who may be witnesses. So the defendant takes the plaintiff's deposition. Plaintiff says, I can't remember the accident. I lost my memory after the accident. And that's the only discovery in the whole case. And there's no affidavits. Can the defendant get a summary judgment?
They can, if the plaintiff's right to go get other evidence has been waived because there's no transcript and no outstanding discovery,
Do they need to do that before trial?
they need to do that when they're
All they
resisting.
have to do is list those other individuals as witnesses.
Right, but and when you're opposing a motion for summary judgment, you have to give the court some indication that you can create an issue of material fact. And that's what didn't happen here, and that's what was waived here. I see that I'm out of town, and I took my my co-counsel's time, so I'm forced to sit down. Thank you.
Okay.
Yep.
No, we're out of time. They're out of time. The appellees are out of time. And you've got about 4.5 minutes left.
Thank you, Your Honor. Addressing what you were just talking about, Judge Evander, I think that you've hit the nail on the head as far as what the issue is in this case. They never got to the point where they shifted the burden to the plaintiff to come forth with other evidence. I think these two summary judgment motions can very much be contrasted with the Lane Wright summary judgment motion, where he did have an affidavit, and that's in the record at 977, that says, I'm not the officer, I'm not the director, I'm not the guy who owns that company, so I'm not personally liable. And in that case, there was no opposing affidavit giving facts as to how he was liable, and so therefore, that summary judgment was entered, and I did not appeal that summary judgment, even though, had they been represented, there probably would have been a way to oppose that better. In the case of Crossfire and Flare Fittings, there was nothing from the plaintiffs to show they didn't actually own the balloon. All we had, I'm sorry, from the defendants, excuse me, to show that they didn't actually own the balloon, that they were not in charge. All we have in the record is my best friend went and talked to them and told them to take it down. They did, and it was them. It's the people that we sued, and that precludes summary judgment. When someone's seeking summary judgment, they have to show that there's no possible set of facts, and the requirement to respond and bring forth facts doesn't get hit unless you've given enough facts to show. A plaintiff does not have to give his whole case in a deposition in order to, to survive summary judgment, as was said. Unless the court has other questions on that issue, I would like to address the release again. Okay. As to the release issue, there is the big difference here is everything in this document, including the in consideration of your participation, makes it appear that it is talking about what's going to happen going forward. It does not make clear that it is also applicable to what happened 2 days before. If they wanted to, to cover something that happened 2 days before, you could have put in language that said, before or after you sign this document. But instead, it's talking about you're going to be participating in this sport, and you're going to be, you need to say that you're able to participate in this sport. And, all of the language in this, including the definition of event, is circular and seems to be talking about the actual participation in the paintball and not in what happened 2 days before you signed this release. And so I think that it was not clear enough to hold as a matter of law that this release precluded Mr. Peterson's claim. Does the court have any other questions? Then I will rely on the rest of our filings and ask that the court reverse all 3 of these summary judgments. Thank you.
All right, we'll take a break and we'll meet the lawyers in the lounge.